No problem. Thank you very much. Thank you for the opportunity to have a say. The Landowners Coalition, I'm an office holder. We're an interested party in all of the cases before the High Court, and we've been actively involved in the Edwards case in the High Court, in the Court of Appeal, and we will be involved in the Supreme Court case that is coming up next month. Our role is to act in the public interest and give the public a voice that they would otherwise not have. Firstly, I must say that it's a bit concerning that the concerns we expressed 12 years ago have come to pass, and here we are today, 12 years later, with correcting legislation.
Really?
I'm also saddened to say that we, the Landowners Coalition, will have to go through the whole legal process again.
Oh,
from the very
boo-hoo.
start.
Boo-hoo. And I'll just interrupt him here.
As it's being changed here today.
Boo-hoo. Let's forget about all the people who put in their submissions to get a customary marine title, right? And the fact that this new act is going to essentially get them to fucking resubmit everything. So, it's just like, oh, boo-hoo, think about our clients. Yeah, I'm sorry. Think about the Māori that have already put their claims in.
Yep.
Get in line.
Yeah.
And vote for more judges.
Yes. Unfortunately, that submission has closed.
In my view, having been involved in the cases, the judges in the High Court and the Court of Appeal have actually bent over backwards to give the applicants customary title. And I find it concerning that the very same judges that made those decisions that are being corrected here today are still actively involved in managing the cases in progress and the 200 or so cases yet to be heard.
It's very known to be standard practice that the same judge tends to manage the case from start to finish. It is not known for you to sit there and go, good evening. Today on the trial we have Judge Snyder. Sorry, spin the wheel. Tomorrow we're going to have Judge Judy Shyman. On Wednesday we'll spin the wheel. We'll have her husband Jerry. And on Thursday we will sit down there and have Chief Justice. Is it Helen Winkleman? Is that our current Chief Justice?
I don't know, but to them they're probably all woke or something.
Yeah, exactly. It's like we're like do they not understand the point of the court is to have the same person in there? If you have a Court of Appeal that smacks down a decision from a district court judge or a high court judge, it tends to go back to that judge to correct. Well, the opportunity goes back to that judge to correct first. And it's even under New Zealand law, not just US law, which we probably hear a lot more about these days.
In my view, that should send a very strong warning to this committee. And the warning is that the law that you make here today needs to be clear and unambiguous. There are 5 issues really I wish to pick up on today, and they relate to sections 57, 58, 59, 160, and finally I wish to make a comment about shared exclusivity. I'll run through these pretty quickly, but with section 57, it's the definitions. We agree with the changes, but what we'd like to see is some firming up of the definition of substantial interruption. And we would recommend this be done by way of an explanatory note, which obviously has no legal effect, but would be a guideline, if you like, to the people who are required to enforce this law and abide by it. So just an explanatory note with examples of what Parliament means by substantial interruption. On to section 58. Now that is the controversial one, and the committee will know it's section 58.1 is really in 2 parts. The first part is the tikanga qualification, and the second part is the continuous occupation and exclusive occupation since 1840. We believe the problem has been that the tikanga aspect has been conflated into the second leg, and that essentially is the problem that this committee is attempting to correct. We believe there's a better way to correct it because we believe there is still a risk that the tikanga qualification will spill over onto 1B, and we believe that should be cut off immediately to not allow the judicial discretion. We believe that can be done by removing clause 58.1. In other words, take the tikanga qualification out and simply rely on 51B.
And ignore English common law.
58.1B as the criteria. Should the committee wish to retain the tikanga clause, we believe a new clause should be added, 58.1C, which would specifically state that tikanga does not apply to 58.1B to make it explicitly clear and remove the judicial discretion. On to section 59, and that relates to matters of relevance to section 58. We believe it should revert back to the clause in the Foreshore and Seabed Act of 2004, and that is clause section 52(2)B, and that basically requires an applicant to hold contiguous title to the foreshore and seabed since 1840 to the present day as a qualification for the granting of customary title. Onto section 160, and that's the burden of proof. And there's a fundamental problem with the Macca cases in the sense that we've got an adversarial process without an adversary. It's a ridiculous situation, and it is much more suited to an inquisitorial approach. And our submission is that that is the approach that the courts should be adopting. Because really you've got a situation where there's only one-sided evidence, and that does not work in an adversarial process. I also believe that section 160 should be amended to expressly exclude hearsay evidence, because from the cases, a lot of it is just hearsay, what went on, passed down from generation to generation without any element of fact.
Okay, now I'm getting mad. We'll stop him there.
Seriously?
Yep.
Wow.
I'm going to be very blunt and quite explicit with my language, but he is fucking wrong. And I'm saying that as a descendant of someone who signed Te Tiriti Iwiko. Okay? And I'm going to quote what the Archives of New Zealand just have stated on this. Māori have been writing for almost 2 centuries. It is not uncommon for whānau, hapu, and iwi and Māori organisations to have manuscripts and other documents, documentary taonga from 1860 onwards, still in whānau possession. This is especially so for whānau with connections to tribal whare wānanga, so those at the houses of learning, and maramatanga, or political movements. Okay, so these are the places where you would expect to have records of tikanga in relation to the land. Okay, they knew the importance of writing. My ancestors knew the importance of writing. I've got access to their documents. Okay, I know my whakapapa. I can prove that. You know, it's just, this guy is to say, oh, it's all hearsay because it's all passed down orally. Yeah, it was originally before Māori understood how to write in English or, you know, utilize writing. But my God, they were quick to get onto that shit when they understood how that worked and the importance of it. This guy is just presenting ahistorical, I'm not going to call it facts, ahistorical rubbish. Tūtai. Ahistorical tūtai. And that's my rant.
Oh, let's continue.
The standard of hearsay is well defined in the Evidence Act, and in my view, that's what should be referred to. So hearsay evidence should be specifically excluded from evidence because it is just so unreliable. The final area, and this is of serious concern to me, is the shared exclusivity issue that was simply touched on just a little while ago. You know, to most people, exclusive means one. It means one particular group or one particular person. Churchman in the High Court,
or one iwi, or one waka,
through a tikanga lens, and he said, it was almost an Orwellian approach in many ways, he said exclusivity can be shared, and he issued jointly held customary marine title. We believe that should be specifically excluded in the legislation, and we submit the bill should prohibit jointly held customary title. But there's another issue that has arisen in the last 2 weeks, and I'm referring here to a minute by Justice Churchman dated the 18th of October, just released last week. and it relates to Ruapuku Island, which is between Bluff and Stewart Island. Now, that is a case that's to be heard in April next year, and there's only a few applicants. But what has happened and what's transpired is those two applicants have now proposed to merge their application into a single application. And Judge Churchman looks as though he may be allowing that. And what that would provide is that those two applications would be withdrawn and the new application in the name of a new applicant would be submitted. Now, in my view, that's offensive from a couple of points of view. Firstly, it's well out of time. The cut-off date was the 3rd of April 2017. This is 7 years after the fact a new applicant has been introduced.
Was it?
And in my view, it is simply a device to get around the exclusivity rule that has now been tightened up. And it certainly has that effect if it wasn't the intention. And that, I believe, is a matter of serious concern, and it shows that the exclusivity rule should be expressly negated in this legislation, and it should clearly prohibit new applications. I have got no objection to joint applications, but the time to make that application was prior to the 4th of April 2017. It's not 7 years after the fact, once they've seen the writing on the wall. Thank you.
I'm sorry. I'm sorry, but sometimes you don't find out facts until after 2017. I used to be an ACT supporter. I didn't find out the facts about their shitty takes until after 2017. Stuff happens. Sometimes new information comes up.
Yeah.
And why would you persist with an application which you know is not the best application to be hearing?
Exactly. Is it illegal to, I don't know, update an application? Is it?
No, not actually. And it's, I mean, it's basically, that would be like, submitting new relevant information. It's very
That's what I thought.
Process. I mean, that even goes into the case of the courts where you'll have, new information put out that, could happen midway through trial, such as, shall we say, an interview on Fox where Trump admits to the crime, and the following day in a trial it could be presented as new evidence.
Yeah. No, I apologize for all the interruptions. It's just, this guy just made me really mad in particular, because it's just like a lot of, it's just
feels
rubbish.
a bit like how, what do you call it, the pet interruptions.
Yeah.
Except I'm having to hit the pause button
It's
because
like, pause.
yeah,
It's like, I need a red buzzer.
yeah.
Refrain from commenting on live applications, just as a general rule for committee members. We have run over time. I will, given that we did eat into your time substantially with the first submission, there is a question there from Takata Ferris, so I will put that question, otherwise we will move on.
Kia ora, Frank. I just note that a lot of what you put forward are actually fundamentals and philosophies from the tangata tiriti side of the treaty. Okay, so they're fundamentally tikanga Pākehā views, like exclusive title or shared title should be thrown out because exclusive should mean one. So that notion is not a notion in Te Iwi Māori. Okay, so Māori are happy to have multiple ownership, to have multiple use. So my question to you, and that's been a reoccurring theme in both of your presentations. So my question to you, and well, actually, I'll just let you know, the exclusivity idea with regards to Ruapuke, I'm a descendant of Ruapuke Island, and Ruapuke Island is one family. So it's just, but by virtue of the nature of Pākehā law, those families have been divided into separate camps. So the best way for that family to put their case forward is as one.
Okay, I think we'll move to the question because I don't want to get
so the
too
question
much on
is very
live
simple.
action.
It's very simple. How do you think the new law should give respect to one of the Māori side of the treaty that signed up to the deal? How do you think the new law should give effect to honouring the Māori side of Te Tiriti o Waitangi?
Well, I think it does, because it gives people the opportunity to apply for customary marine title. The essence here that we're dealing with, it's about quantum. How much should reasonably go into customary title? The Parliament of the day said anywhere between 4 to 10%, around that area. The court's ruling would indicate it's more like 90 to 100%. This is really the essence of what's going on. The right is still recognised. It's about to what degree.
Surely you recognise that
okay,
the
unfortunately,
degree to
we
which
will-
Māori
we-
use their coasts
No,
was
sorry, we
determined by
will-
them.
No, we will be winding this up now. We are significantly over time. So thank you, Mr.
Thank you.
Newman, for your submission. We appreciate your time this afternoon. Members, will move on to our submission now from the New Zealand Law Society,
And racist.
Kahui Turi o Aotearoa. Thank you for those comments, Mr.
Okay. God, that was interruption hell.
Sorry about that.
Yeah.
You got any thoughts, Chris?
Oh, man. None more advanced than where I was before, which was, what are they so afraid of? I mean, seriously, a decent, solid chat that is evidence-based and historically sound. What are they afraid of?
Oh, it's the evidence that don't suit them. I mean, put it this way, in Wellington, they would be part of the anti-cyclone brigade going, hang on there, I don't agree with the evidence, so the evidence is wrong.
Yes, well, Ruapuki apparently was the site of 3 chiefs signing the Te Tiriti o Waitangi.
Mm-hmm.
So for something that's just a small speck of an outcrop of an island, holds quite some significance.
Yeah.